Yes, prosecutors make mistakes, especially during DUI trials. Hi, I'm Matt Landsman, board certified criminal trial attorney with more than 20 years of experience. And I wanted to take this opportunity to talk about some common questions I get about DUIs. That's one of the most common areas of law that I get asked about. And a case came out named Sheely v. State that kind of answers some questions. So I wanted to talk about it for everybody. I thought everybody could be helped by this. So, more people ask me about DUI than any other area of criminal law. And in this case, Sheely v. State, uh, it kind of goes through some issues which uh, could help understand the whole process. So, for more than 50 years, police and prosecutors have faced kind of like a frustrating challenge, like a problem, and that is how to distinguish between people who have had a few drinks and are not impaired by alcohol and are driving, and people who've had some drinks and are impaired by alcohol, specifically to the point where their normal faculties are impaired. So there's kind of a problem there because drinking and controlling a vehicle itself is not illegal. It has to do with your normal faculties. So to bridge the gap in trying to figure this out, the police have kind of developed criteria that they look to try to figure out if somebody's impaired or not. And this criteria is not only just practical in terms of like who they're stopping and who they're going to arrest to try to protect the public, but it also has to do with evidence and how they present evidence in court. So I'm going to go through that, and this case kind of explains this a little bit, and I'll kind of go through it. So let me break it down into three main areas in the same way that they would in terms of how they would prosecute somebody and how they would think about it. So there are these three areas. The first is a driving pattern. That's kind of the first area that the police and prosecution they look to figure out is somebody impaired or not, but there are their normal faculties impaired. And that means, are they swerving? Are they speeding? Are they drifting? Are they failing to signal? These are all kind of circumstantial pieces of evidence they can have about the driver's faculties. Another thing that the police and prosecution looks to in DUI trials and in DUI cases are field sobriety exercises. And if you don't know what those are, think of like Simon Says game, except being administered by law enforcement, having to do with things, physical activities you do on the side of the road. Now, there's a couple problems with that. Is that they're number one, they're subjective in terms of who their test is being administered on. Everybody's unique individual, but also the way it's administered can also uh, have individual errors with it, or the could cause some sort of deviation in how it's analyzed. And the last thing to focus on for DUI impairment and stuff like that and faculties is technology. That's the third kind of branch of evidence that police and prosecutions are going to look to. And that is basically like your breath alcohol concentration, blood alcohol analysis, things like that. Kind of like the science and technology that's gone into trying to prove if somebody is impaired by alcohol. But it also, there's some overlap there with medical science. So basically, none of those tools are perfect. And when someone has the nerve, or for whatever reason has the ability or nerve to challenge that evidence in court, they're innocent. They think the evidence isn't sufficient for whatever reason. They're theoretically they're forced into it. The point is that uh, sometimes when things are going through for the trial, uh, and that forces the state to actually meet their burden of proof, sometimes the government doesn't handle it gracefully. Sometimes it doesn't go over very well, and there's problems in the way the trial is executed by the state. So, in fact, sometimes they overstep the boundaries of what is permissible, and they kind of stop thinking correctly about the law in terms of the Constitution or Florida statutes. So in this case, Sheely v. State, it kind of explains some of the constitutional boundaries that should be controlling the government and the executive branch, and I'll get into that. So in this case, this is a defendant who went through the whole rigmarole about a trial. So they were arrested, they went to pretrial proceedings, there was a trial, they were convicted at a jury trial, and were ultimately sentenced. So all those things had to happen for this case to come about. Now, during the appeal of this case, the Fourth District Court of Appeal of Florida reversed the conviction. The question is why? Why did they reverse this conviction? And so the answer is that the prosecutor made a critical error in how he was prosecuting the case on the day of the trial. So that means this also, the defense would have had to properly object under the different circumstances, and then maintain the objection, and then preserve it properly, and then for whatever reason the uh, the sentence wasn't over short enough that he actually thought it was worth to appeal, things like that. And then at first, the fourth DCA handled it, and then they decided that it was worth writing about and reversing on. So in this case, the Fourth District Court of Appeal judges determined that the error was that during the closing argument of the case, the prosecutor commented on the defendant's decision to remain silent and not and also to not that he didn't participate in the field sobriety exercises or breath test, which are voluntary. So here's what was said. I'm going to read it. I'm going to read it line by line. The quote from the case: um, "A defendant." So in quotes, "The defendant says no when taken to a room safely designated for him to perform field sobriety exercises to dispel the suspicions. He had an opportunity to dispel the suspicions, and he also declined to dispel the officer's suspicions by submitting to a breathalyzer test." That's language that the prosecutor used in Sheely v. State on August of 2024. So let me be clear, that is not just inappropriate, it is unconstitutional. They can't say that. They can't argue that. It's improper. Now, what the law actually says is that every defendant in the U.S. has the right to remain silent, and the prosecution is not supposed to be commenting on that. The right is enshrined in the Fifth Amendment, and trial law is pretty clear on this. The prosecution cannot comment on a defendant's silence or suggest that exercising that right is evidence of guilt. That is prohibited. Uh, More importantly, the burden of proof in a criminal trial lies entirely with the state. It's another kind of principle that goes together. So the defense has no obligation to prove innocence, obligation to offer explanations, or dispel suspicions. It's like a common thing you hear from police when during an arrest, something like that. But that just because the police say that on the road doesn't mean it is proper for a lawyer to be saying that in criminal court, specifically, certainly not the prosecutor during a closing argument. Now, the moment a prosecutor suggests otherwise, like in this case, it's called burden shifting, and in this case, they shifted the burden and improperly, and that undermines the fairness of the trial. So, as the court emphasized in this Sheely case, these comments were prejudicial. They violated the defendant's constitutional rights. The conviction was reversed and remanded for a new trial. Now, the reason this matters, what does it mean for everyone else? It means that the justice system is not perfect. It means that even today, constitutional violations happen in courtrooms across the country. They certainly happen in Florida. And it means that you, if you're ever accused, need a defense that's vigilant, because you have to do these things on the fly, like while real time, while this is happening, you have to catch these things and try to stop them up at the time. And even if you're not accused yourself, you need to you want to see the value in other people having a defense and due process, since it affects your rights. So even if it's just because if you think, well, I would never do anything wrong, so I don't need to be concerned, you want to have other people being defended too, because they're really defending everyone's rights when you have fair trials and fair procedures. So think about this. The defendant in Sheely had to go through a flawed trial, endure a conviction, and appeal, all to get back to square one. That's a long and painful road. There's a lot of time, expense, and emotion that this defendant would have to go through. And that shows us why due process matters. That's what it ultimately shows at the end. Police and prosecutors are not evil. They are human and they make mistakes. They cut corners sometimes, and sometimes a core legal principle can get bent. Why it gets bent? I mean, it makes getting a conviction easier. It makes the job easier to not learn about the law or to execute it properly. But that's where the defense comes in. If having defense attorneys who are vigilant and knowledgeable about trial practice and protecting your rights, is the goal of which is to try to stop things like this from happening. And you see cases get published around Florida, around the country, that kind of document these kind of mistakes that happen. So that's where the defense comes in. If you want to read more about the Sheely case, I've linked the opinion into my blog. And if you found this video helpful, be sure to subscribe and share. Until next time, Matt Landsman for you.